So I'm joined today by Becky Annison. She's the head of engagement for the Chancery Lane Project. It's a wonderful initiative headed out of the UK, but with an international reach to help lawyers like us implement responsible contracting principles with respect to the environment. And let her tell you a little bit more about Chancery Lane and all the wonderful work they're doing. So thanks so much for coming on today, Becky.
Thank you. Thank you for inviting me. I was going to start by saying I think the core principle of really what we're trying to get to is that as a business, if something is important to you, if something really matters, then you put it in your contracts. And for a really long time, I don't think that we in the business world have been particularly good at putting climate into our contracts unless there was a specific piece of environmental regulation that required it. Um, and so our organization came from the idea, well, if it matters, it'll be in the contract. If you want to get it done, it'll be in the contract. But drafting from scratch is really hard, actually. There are very few lawyers, I think, who, as a matter of practice, day in, day out, sit down with a blank sheet of paper and write something from scratch. Most of us are working off precedents. So the concept of the Chancery Lane Project was, well, we need to get people together in a room. We need to get drafting some precedents so that people have got somewhere to start from to make it just that little bit easier to start getting climate into the contracts.
Let me just say, so I did international arbitration for about 10 years before I came to California and kind of focused on arbitration and litigation. And at least in international arbitration, you're very rarely working off precedents. It's very often a blank sheet of paper, and it's very difficult to start from the blank sheet of paper. So let's just be fair about that. But I appreciate it, particularly in the transactional corporate world. It's very much you're kind of iterating off precedents for the
Yeah.
most part. And yeah, and just to give you I think I mentioned before at the start, so I've been involved with the Model Contracting Clause project for a number of years now, which addresses human rights in contracting. And we say much the same thing as far as if a company really cares about implementing these procedures and processes, you should have them reflected in your contracts. You should have them set out in an orderly arrangement, because the contract is what guides the framework of the relationship. So if you really do care about this in the context of the relationship, you might as well spell it out. And I think the process of contracting with the counterparty shows to that counterparty that it's also important to you. If it's not important enough to put it in the contract, it's very unlikely that the counterparty is going to care enough about it.
The thing that I often find myself saying to people is, you would never, as an in-house lawyer, that's my background, I'm an in-house lawyer, I would never have walked up to my chief financial officer and said, I've just got this amazing deal. It's brilliant. We're going to make 20 million a year. But I haven't bothered putting that number in the contract because, we all know that we've agreed it, and it's fine. You would never leave the price out of a contract. You would never leave the delivery times out of a contract. But we routinely leave climate, and I think you're right, human rights out of the contract. And I think that does say something about how important it really is.
Yeah, and I mean, and I would expect it similar in the context of environmental issues. We're not trying to say that you'd necessarily terminate a contract because of a violation of human rights or environmental obligation. In all honesty, you probably wouldn't want to motivate termination of the contract, because that just incentivizes covering up the issues. But you do want the obligation to be enforceable, and you do want the obligation to be hard enough that it's set out in the contract, and you want, in the best case scenarios, you want a situation where the contract also delineates what you do in the event of a breach. So it's not just terminate, and it's not just kind of an ad hoc, let's come up with a solution, but the contract can set out ways of addressing those. And of course, being a disputes lawyer, I'm much more focused on what happens when a dispute arises, because, transactional lawyers say if a contract's written well, then there's going to be no dispute. What I've found is that parties just eventually come to differing understandings of what they want out of their relationship, and that leads to disputes as well, even in the best written contracts.
I think you're
Maybe
right. Not,
taking
I
a
would
couple.
say
Yeah, you go.
I was going to say I would take it a little bit further than that. But I'm a transactions lawyer. I was a transactions lawyer before I became the head of engagement, and some of the contracts that I worked on were vast, and I mean 10 or more binders of schedules that people have to comply with. And the reality, I think, the dirty reality that we don't talk about enough as lawyers is that when you have a contract that's that complicated with 10 binders of schedules written by human beings, many of whom may be writing those schedules at 2 o'clock in the morning, if we're really honest with ourselves, you are going to get breaches because it's not really possible as humans to internalize even creating the best processes and systems in the world. We're running contracts now which are just too complex for perfect compliance, I think.
Mm. Yeah, and I mean, in the human rights context, it's also just reality of the global economy that supply chains are so integrated and so complex that there might be instances of issues. Similarly, in the environment. But let's take a couple steps back. I'd like to learn a little bit about you, Becky, and how you found yourself here.
Oh, well, thank you so much. So, I trained in a London city law firm, and the thing that taught me, with a huge amount of respect for my colleagues in private practice, but what it taught me was that I needed to be in an in-house environment to really thrive. So, as soon as I qualified, I went straight in-house to a large multinational construction and services company. I was there for nearly 13 years, and you know what? I really loved it. I loved sitting in a company. Um, I loved having my desk next door to the procurement team or next door to the developments team and really being completely rooted in the business. And I found that really energizing and really exciting. And I think it gave me a really important and interesting perspective on the kind of the nuts and bolts of how not only contracts get made and negotiated, but how they get delivered, which was a really interesting experience for me. And when I eventually parted ways with that company, then I went and spent I think it's about 2.5 years working for Practical Law, actually. And I know that that's much bigger in the UK than it is in the US, but there is a US presence for Practical Law. And when I was there, I actually worked on the in-house sector team or the in-house specialism team. So I wasn't an in-house lawyer for Thomson Reuters. I wrote content. I was an editor. So I wrote content for in-house lawyers like me to help them navigate things. And what I eventually ended up specializing in while I was there was, and people always laugh about this, which is I worked on advice for Brexit. I worked on
Okay. Oh, like how to deal with Brexit?
how to
Yeah.
deal with the potential consequences of Brexit as an in-house lawyer, not knowing at that point what any sort of deal was going to look like. So how
Oh,
do you
yeah, of
prepare for
course.
that unknown?
Yeah. Yeah.
I worked on advice for in-house lawyers dealing with potential recessions.
Mm-hmm. The following from the Brexit implementation. Yeah.
Following
Okay.
from potential Brexit implementation,
Yeah.
advice for in-house lawyers on climate change and advice for in-house lawyers on pandemics. And
Okay. Okay. So you were kind of working on the very new, immediate, kind of cutting edge issues, which is really interesting and exciting. That's what I love about this space in general as well, is we're working in this really fast changing new environment, new legal environment.
exactly. And I think what I found so satisfying about it was as an in-house lawyer, obviously you are incredibly busy all the time. You're just firefighting whatever is coming onto your desk, and you rarely have the time and sit and think, if there was a recession in 6 months, what could I do today that would put my business in the best possible position to ride it out?
Mm-hmm.
And so it's just a really satisfying job to kind of have the time and the space to write that, knowing that the things you were writing were important things that in-house lawyers were really going to need but didn't have the time to do for themselves. But that was where I first started getting into climate change, because I had never done any climate or environment at all prior to this. I had been a contracts lawyer, I've been a deals lawyer. I'd done no work at all. I don't have an environmental law background. I have a contractual law background. So working on climate change from that perspective was really interesting. And then that's obviously what led me to joining the Chancery Lane Project nearly 4 years ago now, and bringing what I hope, bringing my experience of living and breathing and delivering on contracts into the heart of the climate space.
I think we've gone nearly 8 minutes, and I'm not sure we hit on the head exactly for audience members who don't aren't familiar with Chancery Lane, exactly what Chancery Lane is and does. So maybe we could take a beat and you could tell us a little bit about Chancery Lane.
Absolutely. So the Chancery Lane Project provides a set of resources, and those resources are contract clauses, glossary terms or standard definitions, if you like, and guides. I'll talk a bit about guides in a minute, but it provides resources to help lawyers put climate into contracts. So it will give you contract clauses as a starting point for you to amend. All of these resources are free. They're freely available on our website, and they were created through a huge and amazing pro bono effort from, I think at the moment we have certainly thousands of individual contributing lawyers, hundreds of organizations, which includes law firms, in-house legal teams, governmental legal teams, NGO legal teams, all contributing together to create a suite of best practice clauses, a suite of getting you started clauses, a suite of standard definitions. So if you have heard terms in the climate space like greenhouse gas, scope 3, if you go on our website, there will be a set of wording there that explains what it is and that you can use this as standard definition. And then from there, we've moved on to creating guides, which are also free on our website. And what the guides do is that they really recognize that it isn't as simple as taking a clause, chucking it in an agreement, and saying, job done. That actually, in order for clauses to be successful, for there not to be a breach, for the carbon savings to be delivered, for the carbon data to be delivered successfully in the way that we all want, there's a whole process that goes along with that. There may be 3 or 4 documents that all need to line up and all need to have their drafting saying the same thing. There might be some due diligence requirements that need to be done to support the clause that goes in the contract. And that's what the guides do, is that they take specific things that you're trying to achieve in your business, and they say, if you want to achieve this, you probably need to look at these 4 documents. You probably want these 3 due diligence questionnaires in this tender over here, and that is going to give you the best chance of making this a success.
That's a wonderful explanation. And so over in Europe, or I guess because of Brexit, you're not in Europe per se, but over on your side of the Atlantic, I'm sure you're dealing with the CSRD quite frequently. Here in California, we're thinking through the implementation of SB 253 and 261. These are environmental reporting requirements. So for instance, if I'm an in-house counsel at a small importer that's still responsible for reporting on my scope 3 emissions, and I have to think through how am I going to put this requirement for information in my contract with my supplier, rather than reinventing the wheel, I could go to something like Chancery Lane and probably find something along those lines about.
That's absolutely right. So partly it's around helping those smaller businesses to do that, because we know that SMEs don't have the resources that the larger companies do. But I think it goes beyond that. When I look at some of the really bold climate targets that companies out there are putting down on their websites, I'm thinking Google, I'm thinking Microsoft, the climate targets that they are putting out there are big. They are really bold, they're really ambitious, and they are running well ahead of anybody's legislation, whether it's California, whether it's the EU, whether it's the UK. So when you are a business that has set a climate target, which is so far ahead of where the regulation and the policy is getting you to, what do you do to close that gap? Now, obviously, I would argue that what you do to close that gap is you put it in your contracts.
Yeah.
And so that, again,
I mean, that's a first step. Yeah. Yeah, that's a first step. I mean, a lot of the work we do as lawyers, especially in this ESG space, is kind of working with consultants who are able to really get into the nuts and bolts of these are the type of levers you turn to reduce your GHG, to do this, to do that. But what we do is facilitate that by setting it out in the contractual documents and the relationship documents.
I think we facilitate it, but I think that one of the things that I'd like people to really get to grips with as lawyers is how much we have the potential to block it. And what I mean by that is, when I was an in-house lawyer, if a sustainability person had come to me with a brilliant idea for how to turn those levers to how to reduce that carbon, there is a very high chance that I would have said, that's great, but that's going to increase the cost of delivering this contract by 25%. That isn't in the terms and conditions. You can't do it.
Yeah.
So one of the things I want people to really think about is that contracts are amazing enablers, but they're also massive blockers to your ambitions and your plans if you're not lining them up. And the other thing that I'd like to add is really important, I think, is in terms of timings. This is something I talk about a lot. I'm really, really passionate about getting lawyers thinking in this way. If you are a company that has set a net zero target for 2050 and an interim target for 2030, but you are signing contracts today which are 5, 7, 10 years long, then if you are not putting climate clauses in those contracts, there's a good chance you're going to bust your 2030 target, possibly even your 2050 target, because it's the contracts you're signing today which is going to lock you into terms and conditions which will determine whether you make it or not. And that's happening now. That's not happening when you're ready in 5 years' time.
Well, and it speaks to how in this space you really need alignment. And I talk about this frequently in the context of the work I do with the Responsible Contracting Project and with the ABA Model Contract Clause Project, where we talk about how you really have to, in order to operationalize the UN guiding principles on business human rights, you have to have procurement and legal and compliance and the board and everyone rowing in the same direction and understanding the obligations that are to be met. One thing that we do at the Responsible Contracting Project is perform gap analysis for companies where we take a look at what they've said about what their goals are with respect to business and human rights, and then look at whether or not the contracts actually allow for them to achieve those goals. I wonder if Chancery Lane or there's any organization that does a similar gap analysis that says, well, you have a goal, you have a target for 2030, but you're signing a contract in 2024, that 7-year horizon, that doesn't speak to this goal. I don't know if you guys perform yourselves or you're aware of other orgs that do it, or.
So we don't do that sort of gap analysis. And honestly, I'm not aware of anybody that's doing it. So there's an amazing business opportunity there for some bright, aspiring young lawyer. I think that what we do is that we will go and talk to corporates and we will say, look, we've seen what's on your website. That's really ambitious. How are you planning on delivering that? Are you using your contracts? What sort of contracts do you think you should be using? Have you heat mapped your contracts? Do you know where your high carbon contracts are? They're the ones that you probably want to put clauses in. We don't offer legal advice, but what we can do is say, of the 150 clauses we have across multiple jurisdictions, and we've recently released 21 clauses covering the US, Australia, Italy, and Germany. I think it's Germany. Yep, that's right. We can say we've got all of these clauses. That's a lot for you to start looking through as a lawyer. Where I recommend you start is these 5, given the business that you're in, given the targets that you've got, given where most of the carbon is sitting in your contracts. I recommend you look at these 5 clauses first.
So being head of engagement and being a former in-house counsel, is part of your role at Chancery Lane to effectively kind of look at different company statements and say, let's not say Microsoft, let's just say company X. You'll read company X's announcement with respect to 2030 and 2050, and you'll reach out to their in-house counsel to say, I wonder if you thought about this part of your business and whether or not you're doing it, because you know that in-house counsel are busy and are putting out fires and don't have the 5 to 10 year horizon that you're allowed to have. And so is that part of your role as an engagement officer, is to reach out to those in-house counsel?
It is a part of my role, but I suppose in a way it's a small part of my role, because I think that there's a piece here about picking the right people who are at the right stage of the journey. And that isn't necessarily what's in their company statements or even what's on their website. Sometimes it's about, there's an awful lot of companies out there, and I won't name them, don't worry.
There's company X's and company Y's and company Z's.
Yeah. There's a lot of companies out there who've got very, very excited. They wanted to do the right thing. They put a number on their website without really thinking about it. They don't have a plan for how to deliver it, and they're panicking. And I think we're starting to see some of those numbers starting to slowly disappear. I think there's another set of companies out there who have really internalized what this means. They know that this is a long slog. They know that this is probably, I'm going to say the secret, this is probably going to cost some money. Because if you want your supplier to deliver something, the same thing, but with a 25% carbon reduction, that might mean investing in new equipment. That might mean changing manufacturing processes, which cost more money. You know, a lot of these solutions are going to cost. There are a number of companies out there, and I'm not going to name them either, who have internalized the fact that it's going to cost money. They're starting to set budgets for that. And those are the companies that it is. We're a very small organization. So I want to be speaking to the right people at the right point in their journey when they're ready to say contract clauses.
Yeah. Yeah, you don't have the bandwidth to be convincing companies that this is what they need to be doing. You'd rather just put yourself out there as a resource and allow for companies to find you.
Yes, exactly. And when they do find us, then I am here, and I'm in me and many other members of my team are happy to have phone calls, do internal training, to help you navigate what is there and the best way to implement it for your business and your sector.
Do your trainings involve only the in-house department, or do you, along the lines of what I was saying earlier, do the trainings for procurement and in-house and all of the different business functions where this would relate?
So my ideal training session is that I would have a decision maker, I would have legal, I would have procurement. If this is like a scope 3 situation where someone's looking to reduce their scope 3 emissions, I don't want to have procurement on there as well, because the in-house background that I come from was one where the legal team worked in total kind of lockstep, in total sympathy with the procurement team. You know, when we ran panel refreshes, when we were looking to refresh our panel of law firms who worked for us, we involved the procurement team and we got them to help us run that. So for me, legal and procurement need to be working in absolute tandem on this.
That's good to know. Yeah, no, I certainly agree, particularly because procurement, they're the ones who are implementing these, and they're the ones who understand the challenges and limitations of something that a lawyer might want to put into a contract.
The procurement are probably going to be the ones sitting across the table from a supplier saying that's going to cost you an extra 10%. And they need to know that the board have got their back, that there's a budget for it. They need to know that legal have got a suite of arguments to help them to close that deal. And this is what I mean, I sort of say, when the reason we moved into guides is because a clause in a contract is it's kind of the end point of a very long process involving procurement, involving the board to get everything perfectly lined up. But of course, once it is perfectly lined up, even if that takes a while, then you'll have a success.
But the guides are basically explaining. So a lot of what we do in the human rights contracting space is write explanatory statements, or honestly PowerPoints, because I'm finding that people in C-suites appreciate PowerPoints much more than legal jargon and long articles.
Yeah.
But what we do is we basically set out the reason why you need these and say, don't worry about, we know that you don't want to read this indemnification clause 15 and limitations of liability. We understand you don't want to read this contractual language. I don't even really want to read it. It's just my job. So I've gotten used to it. We understand you don't want to do this. We've got this covered, but this is why we're trying to do this. Yeah.
Yeah, absolutely.
So maybe you could tell me just a little bit more about some hypothetical use cases for the Chancery Lane and maybe perhaps for lawyers or in-house counsel that wouldn't even realize they would need to use Chancery Lane.
I'll start with the simplest one, which is procurement, because that's sort of my natural home, and I think it's also the easiest one to explain through contracting. So ultimately, you want to reduce your emissions as a company, but as with most companies, the vast majority of those emissions is almost certainly in your scope 3. So that's going to be your supply chain, your value chain. Now, the good news is that you at least have strong contracting relationships, and presumably because you're spending money with these people, you have some leverage in order to get your contracts signed and agreed. So we'll start with some simple scope 3 reduction clauses. So the first thing you probably want to do, and we have clauses that cover all of this, but the first thing you probably want to do is to say, okay, well, I have set a net zero target, so I have a particular pace that I am now working to in order to deliver that target. And so I need my suppliers to match that pace. So I need them to set targets which are at least as ambitious as my own, so that we're all heading in the same direction at the same pace. So that's the first thing. Then I would say, well, now I'm going to need some really good data, actually, because I don't know if I'm hitting my targets, because most of my scope 3 emissions, most of my emissions are in the supply chain. So I need my suppliers to be giving me really good, solid information so that I know if I'm hitting my targets. So I'm going to start asking you for some really high quality data. This is usually the point at which people start asking for money, because capturing that data, making sure it's good, reporting on that data is something which starts to cost. So I've got my data, I'm heading in the same direction. Well, the next thing I want is some actual carbon reduction, but we're going to start by just setting a carbon footprint for this contract. So we're going to say that for the life of the contract, all of the business operations relating to this contract are not going to come to more than X tons of carbon.
Okay.
So now we have something which we're starting to have like.
You're almost like backing into a reduction, because you're almost saying at some point we're going to have to reduce.
Yeah. But before you reduce, you need to get good data and you need to have a baseline.
Yeah.
So those are the clauses. Then I would say, right now we can start talking reducing. So now we'll say that on the anniversary of the contract, that carbon footprint is going to reduce by 7% year on year for the life of the contract.
Now you mentioned, so one thing Chancery Lane obviously can do is give the language to facilitate this. I wonder if, because you mentioned that there's a gradual process where costs begin to increase. Do your clauses include any indicative pricing for this carbon reduction? Just so if I'm an in-house lawyer and I'm asking somebody to reduce their carbon output by 20%, I don't actually know how much I should pay in exchange for that. There's no market necessarily. I mean, there's some, but how does Chancery Lane dip its toes into some analysis of what market practice is with respect to paying for these things, and if not, are there other resources?
So we don't. I think that is something where I don't think there's anybody in the world quite ready to do that yet, or it may be some of the bigger consultancies out there. But the reason we don't is that we're providing the framework, and it's going to be down to your specific business, your sector, the specific thing you're asking your supplier to do. And I think that because that could be so wildly varied, that could be everything from this can of Coke has to be 50% thinner to this manufacturing plant now has to switch over its entire processes to solar. And the variance in those is so big that that's exactly the sort of thing we've left to the companies. If I had advice for in-house lawyers in that space, I would be saying, get involved in trade associations and industry groups where that sort of data is going to start to get shared. But also, you talked a lot about joining up with a procurement team. This is where you join up with your sustainability team. What are you hearing, sustainability team? Does this look right? Have you heard of anybody doing this better, cheaper? Is there another part of the business which is doing this better, cheaper, and benchmarking that? So that's, I think, where you bring in your sustainability team to support you. But I think that the next step for lawyers, there's a couple of different steps here. I think the next step is, what do you do if somebody breaches that requirement? Because as you've said,
now you've tantalized me as a disputes lawyer. Okay.
That's the next lawyer's bit is, what do? Do you terminate them? And I think that, and we do have termination clauses in our suite of clauses, and that's because you always have to have that backstop in there. You always have to have that right, even though the reality of the situation is you're never going to use it. And I will be honest, and I'll be very practical and pragmatic. If I have somebody who is delivering on time, on budget, for the product to the specification that I have asked for, am I going to terminate them and run a completely new re-procurement process at great cost and possibly miss my own deadlines because they didn't give me the carbon data by the date that I said? No, I am not. There isn't a business in the world which is going to do that. But you have to have that clause in there.
But you might discount how much you're paying, because if you're
Exactly.
buying something that's non-conforming, you might still buy it, but you might offset some of it. So if you had a process whereby you're fixing some type of price exchange or exchange of value in return for this, you might offset what you've said you're going to exchange. So you're not going to terminate, but you're going to be incentivized to enforce the clause, and the other party is going to be incentivized to actually take up on its obligations. That's the idea, at least.
Exactly. Exactly. And there's a number of different ways you can do that. So one of our clauses says that, okay, so you missed the carbon target. We're not going to terminate you, but you now have to buy high quality offsets. And I know that offsets is a very difficult subject, but we are talking about a situation where the carbon has been emitted. We can't reduce it. So we're just trying to claw back what we can. You have to buy high quality offsets to the value of the carbon you missed the target by. And whilst I think offsets are a really tricky thing, the reason that I still like that provision is that there is no windfall here. There is no, we're going to get damages because you missed the carbon target, but now we've profited from the carbon being emitted. That strips all that out. Nobody profits from this carbon being emitted. It's purely about remedy. Maybe offsets are not the right for your business. Maybe you'll want to put it into a resilience fund for a small local community that's having problems. There's a number of different ways you can spend that money, but the key is that money doesn't go back to the customer. So that's the
So
first thing.
we talk about that in the human rights context as well. The
Yeah,
idea is if somebody breaches a human rights clause, you don't want the buyer to profit off of the breach of the human rights. What you want to do is make sure that's directed to remediating the human rights issue.
precisely. The other option, which I've seen, which is actually being used in real life contracts, which I think is really great, that they're in the UK. The UK Environment Agency is one of the organisations using our clauses. We've got a couple of others I can talk to. But what the UK Environment Agency did, which is really interesting, let me give you a bit more context, actually. Why does
Okay.
it matter? Why does it matter that the UK Environment Agency is using our clauses? The reason it matters is that here in the UK, our Environment Agency is responsible for flood defences, and flood defences are made of steel and concrete, and they are incredibly carbon intensive structures, construction projects. And so the Environment Agency is in a slightly odd position in the UK of having to spend a lot of money on potentially carbon intensive projects because of flood defences, whilst at the same time trying to defend the UK, and look after our climate and our environment. So they're in a really interesting position. And they said, and rightly so, the construction industry is notorious for having high risk and low margin. It is almost impossible to get a set of liquidated damages, the sort of thing I've just discussed about, paying for those offsets. It's almost impossible to get that through in the construction industry because they're already operating on such incredibly thin margins. So what the Environment Agency did was took that same clause and they said, if you fail to meet the climate target, then that's sad and we'll all be very depressed. But if you beat the climate target, if you
Okay.
save more carbon, then we will give you a price uplift.
Okay. That's which is just another way, carrot and a stick, and
Yeah.
you can use carrots, and you can
Yeah.
incentivize. And to the point, we all know that this is going to cost, and it makes sense to say, why don't you recover that costs after you've been successful? Yeah.
Yeah.
Okay.
Absolutely.
Yeah.
Absolutely.
And it puts the onus on the construction company to perhaps come up with ways so that they're being as efficient as possible in meeting those targets so that they can eventually get rewarded even more than just the costs that were required to reduce the carbon in the first place. So yeah, that's a very interesting way to go. And it goes back to our original point where we've been thinking about this for years. Most contract lawyers don't have the bandwidth to think about this. So most contract lawyers don't want to have to reinvent the wheel all the time. So
Yeah.
that's why these clauses are so valuable. And maybe just tell me a little bit more, I guess for our American audience. So do you have, are your clauses written by US lawyers that have UCC backgrounds? And
So the vast majority of those 150 clauses are UK based. However, there have been some amazing work done by US based lawyers to take those clauses and amend them and make them suitable for a US context. The one thing I would say, in addition, I don't want to take anything away from the brilliant work they've done, but the other thing I'd say is that we're both common law jurisdictions. We are, the US and the UK are both jurisdictions which have a lot of freedom when it comes to contracting, much more so than civil law jurisdictions. And so even though the clauses, the ones that have not been Americanized, there's probably still some really good ideas in there that you can please feel free to take and use. But I would start with some of the Americanized clauses, particularly the ones around due diligence, because I think that the due diligence clauses do a couple of really important things. Firstly, there is so much legislation coming in now requiring more and more due diligence around climate. You've mentioned the California regulations. Obviously, there's CSRD and CSDDD coming in the EU. And even if you are a US-based company, if you are part of a big EU company supply chain, then there's every chance that they're going to ask you to comply with those reporting requirements, even though it's not a legal requirement on you. If it's a legal requirement on your customer, then they're going to want that from you. So due diligence is a really, really hot topic. I think our work is a great way to kind of get ahead of that before it hits your company. But the other reason why I'm such a really big fan of due diligence kind of goes back to what I was saying before. If you're going to run a supply chain, a procurement exercise to buy paper clips, then you're going to do some due diligence on the people tendering to make sure they can actually supply paper clips. So if you are somebody who needs your suppliers to help you meet your climate goals, you are going to need to do due diligence on those suppliers to find out whether they can actually do the work that you need them to do, and that includes carbon reduction. So I know that that there are some great due diligence questions, and that those have been fully Americanized, and I think that is going to be a really good place to start, because it gets people thinking about the issues. It starts to tease out some of the costs, but without it actually costing you anything at this point. You're just getting information, and that allows you to make good decisions.
yeah, what is it? You can't manage what you can't measure, right?
Yeah,
That's
exactly.
that sounds like a very American Harvard Business School. um, so I really appreciate you being so generous with your time and just and on this morning's call, but also in general the work that you've been doing. It's really wonderful and a helpful resource to us lawyers out there. And just before we go, we often try to talk about where do you see kind of the future of this space. So I'd be curious to hear a bit more about what you think is on the horizon.
Oh, my ultimate goal, our big ticket end goal is that we are completely irrelevant as an organization, because these clauses are boilerplate. In the same way that you put a termination clause in, you put your climate clauses in, and you don't need Chancery Lane Project to help you show you what to do or how to do it, because it's part of your day job. I mean, I think that's everybody's end state goal. Where it's going next, I think, is going to be really interesting, because I think there's a lot of companies out there on both sides of the Atlantic who have not yet fully understood how much climate change is going to cost their business off the bottom line over the next 10 to 15 years, and how much their business is going to need to change in order to keep up with the world as it changes and as the climate changes over the next 10 to 15 years. I think that we're going to see clauses like this going into contracts out of necessity, because the risks are going to get really high. And I would like businesses to understand those risks to their businesses a lot more. And I would like lawyers to advise on those risks. And I'm going to give you some examples if you like. If I was an in-house lawyer now working for a large organization, if we were going to buy a hotel chain on the coast, I would be looking at whether that hotel chain was going to be underwater in the next 5 years.
Mhm.
If we
Mhm.
had a critical supplier in certain parts of the world, I would be asking that supplier in my due diligence questions, are any of your warehouses in wildfire areas that I should know about? Or any of your warehouses on floodplains that I should know about? Because I think that the risks to business now of the climate breakdown are absolutely huge. And I don't think lawyers have quite caught up with that. So
Mhm.
I think that that's the next trajectory I'd like to see. Not only I'd like to see these clauses in contracts, but I'd like to see lawyers of all different types and varieties and disciplines, not just environmental lawyers, really starting to look at the risks of climate change and advise businesses on those risks.
Mhm. Yeah, and you mentioned environmental lawyers. I think it's important to say we don't just need lawyers who are specialists in the environment. What we need is lawyers who are specialists in commercial issues and commercial relations and commercial contracting that have a background understanding of all of these environmental and social risks. I think that's what's really important to have.
And I think it's the risks that are the important thing,
Yeah,
because where we have environmental regulation, well, that's easy. That's a
yeah,
law. That's written down.
yeah,
That's a box ticking exercise. I can do that.
yeah.
But we're talking about having the horizon scanning capability to say, is that warehouse going to be underwater in 5 years? And what does that mean for this critical path of my supply chain?
Or with respect to, we talked about carbon offsets. Are these going to be legitimate, credible carbon offsets? Or are these going to be something that are going to be to subject my company to scandal in 5 years because
Absolutely.
they're not verifiable? So having this kind of industry specialization understanding is important, but having it grounded in a rigorous commercial law background is also important.
I think so. I think so.
Well, listen, thank you very much for your time today. I really appreciate all the work that you're doing. And we'll have a link if you want to in the show notes to the Chancery Lane Project. Chancery Lane. So this is a lane in the City of London where a particular barrister house is. Is that it?
It's the lane in London where all the lawyers live.
Where all the
So
lawyers.
many law firms started out having their offices on Chancery Lane.
Okay. Okay. So that's where we have it here. Okay. So thanks very much for your time, and we look forward to hearing more from you guys.
Thank you, Patrick.